distinction.
Are you saying that you have some inputs which you have not disclosed it to him and which is with you, which you will be sharing it with the court?
We are not demanding freedom from India. Again, my lord, Gandhiji comes. There is, my lord, a sandwich. Bread on this side, bread on that side. Again, at the cost of repetition, your lordship are dealing with a person who is instigating people in an area which is a border area, bordering both Pakistan and China. And there are certain region-specific sensitivities involved.
According to you, these talks are all would constitute a threat to the country.
Now, please see, my lord, your lordship would examine whether, as Supreme Court says, my lord, he was given a fair treatment. That's the ultimate, my lord, test. Fair treatment, one of the part would be that existence of material and material which is not irrelevant for the purpose of the objects for which this act is enacted. Second would be strict adherence to the provisions of the National Security Act. Kindly, my lord, take the act and I'll show, my lord, the strict adherence.
So, according to you, these talks are all would constitute a threat to the country.
Threat to the country, public order.
All right.
My lord, therefore, I wanted to read section 3.
All right.
And my lord, again, my lord, going back to the judgment which I cited, that it is not a punishment for having said that. It is a preventive action that he does not keep on repeating that and therefore preempting any such action. So that's what your lordship said, my lord, in the judgment which I cited on the last day. As soon as may be, but ordinarily not later than 5 days. See, my lord, this is the latitude given because of the very nature of National Security Act. But it is given in this case, my lord, immediately.
They are not complaining on this at all.
So, and my purpose of showing this, when your lordships in the earlier judgments have said that the judicial review would be restricted to see that he got a fair treatment. But one of the aspects of fair treatment is whether the screening at several levels which is stipulated by the legislature is scrupulously adhered to or not. That's my lord, these are the inbuilt checks and balances. So my purpose is, my lord, reading this is to show and satisfy lordship's conscience that he is given a fair treatment, that there is material, the material is not irrelevant, sufficiency your lordship would not go into, there is a inbuilt checks and balances, and those provisional checks and balances, those checks and balances provisions are scrupulously adhered. That is, my lord. So these are all, my lord, provisions made to prevent any abuse, whether purposeful or unintentional.
The sort of procedural safeguards are being
Safeguards,
followed.
so that
That's what you
intentionally or unintentionally there may not be any injustice to someone or arbitrary action, my lord, at the behest of the executive. The nature of the power, the very object for which the act is enacted, there is certain leeway which is given to the statutory authority. Well, that's what another purpose, my lord, why I am showing this. Here, my lord, the grounds are supplied immediately, but please see too, what is the leeway granted? Because this is a leeway specific to the object of that. Of course, we have not invoked this provision. I am just showing, my lord, the provision itself. Subsection 2, kindly see, my lord. This is another leeway because of the very object for which the act is enacted. Subsection 2 of section 8.
Yes.
Nothing in subsection 1 shall require the authority to disclose facts which it considers to be against public interest to disclose. Now, my lord, kindly see, my lord, in fact situation of national security, lord, we have certain intelligence inputs. The intelligence inputs are always given by the informants. There are several confidential things mentioned in the intelligence inputs. There is a statutory protection that you need not supply to him. Grounds you must supply to. And therefore, my lord, I will assist your lordship on the question of referred documents and relied upon documents. There is a specific categorical distinction.
Are you saying that you have some inputs which you have not disclosed it to him and which is with you, which you will be sharing it with the court?
No, I am not saying that. I am saying, my lord,
by claiming, of course, you can claim privilege under the Evidence Act 132 or 133.
One of the arguments.
Evidence Act.
I'm not on that. Your lordships are right, my lord. It's a claiming privilege. There is a separate procedure. I'm not going into that procedure at all. I'm not invoking.
That is in sync with subsection 2 of section 8.
Yes, I am not saying that I am entitled not to supply. In fact, I am only, I'm not showing this section for this purpose. The section is shown scheme of the act that there is a latitude given because the object of the act is of a particular nature. Then, my lord, 9. constitution of advisory boards, the central government and each state government shall, whenever necessary, constitute one or more advisory boards for the purposes of this act. Every such board shall consist of 3 persons who are or have been or qualified to be appointed as judges of a high court, and such persons shall be appointed by the appropriate government, Lord, etc. We have this board, my Lord, and it's nobody's case that there is no such board or it is not composed as per section 9. It is, my Lord, decided by a former judge of the Jammu and Kashmir High Court. Now, section 10. Save as otherwise expressly provided in this act, in every case where a detention order has been made under this act, the appropriate government shall, within 3 weeks from the date of detention of a person under the order, place before the advisory board constituted by it under section 9 the grounds on which the order has been made and the representation, if any, made by the person affected by the order, and in case where the order has been made by an officer mentioned in subsection 3 of section 3, also the report of such officer under subsection 4 of that section. Lord, scrupulous compliance, Lord, I'll show that within time to the authority contemporary.
Not raise that contention at all.
That's the fairness. That's the only part your Lordship would examine. That's followed the respectful submission.
No, why should we examine which has not been canvassed by them? They have not canvassed that at all.
We are not demanding freedom from India. Again, my Lord, Gandhiji comes. There is, my Lord, a sandwich. Bread on this side, bread on that side. In between, if it's a chicken, it becomes chicken sandwich. If it's vegetable, vegetable sandwich. The detaining authority is not concerned with the bread. He is concerned with what is in between. Now, Lord, again,
Why don't you use butter also?
Yes.
Or burger or the Genji.
Yes. We are not demanding freedom from India. We want to remain a part of Mother India. But we are asking for our rightful safeguard, the right to choose our own government, the right to choose our own representative and protection under the 6th schedule. He added that Tibet and China enjoys more autonomy, and Skardu, Baltistan under Pakistan have an assembly which is denied to Ladakh. If needed. So kindly see, my Lord, again at the cost of repetition, your Lordship are dealing with a person who is instigating people in an area which is a border area, bordering both Pakistan and China. And there are certain region-specific sensitivities involved. If needed, I have connections across the world. In Asia, with the Magsaysay committee, in Europe, with the Rolex committee, and I have also heard that so-and-so aspires to get so-and-so prize, and I have links with the committee, that committee too. It may be a little self-praise, my Lord, but that cannot be an objectionable thing, my Lord. Now, please see, my Lord, the National Security Act, and I'll show, my Lord, scrupulous adherence to that. Lord, that is the real test of judicial review in a matter of preventive detention, that existence of reasons without going into the sufficiency, except if the reasons are completely alien or irrelevant. Lord, in my respectful submission, they are the most relevant reasons going to the root of the matter and strikes at the very purpose for which, my Lord, the National Security Act is enacted. Because now, my Lord, we will have to cover grounds of detention supply, alleged non-supply of 4 video CDs, which we have an answer. It is supplied, it is shown to have been supplied, and there is an opinion of the advisory board on that, and my Lord, some other incidental.
No, his main thrust of the argument was the detention order itself and the grounds are cut, copy, paste.
Yes, I just point out, my Lord, that. As I indicated, my Lord, yesterday for your Lordship's kind consideration. My Lord, what I gather, the Lordships, my Lord, rightly used the expression as argued that you have decided on borrowed information. Yes, well, that was your Lordship, my Lord, a very pertinent question. My Lord, I am given the information by several sources. My Lord, as I indicated yesterday, suppose somebody were to show the order of the court that Mr. So-and-so has misbehaved with the court, so it is not necessary that I write or paraphrase the whole thing in my own way. I say that yes, I have read it and I am satisfied that this does make out a case for my exercise of powers. Lord, he could have smartly, Lord, paraphrased it in a different language.
Citations that they have relied upon the volume. Authorities.
Lord, it would have been a separate issue if we would have not said anything and just signed it that I agree on that. pass the order of detention. No,